Hello, my dear students. So, in the last class, we started with our one of the important sections, section C, 40% coverage, corporate laws, right? So, we are basically preparing ourselves for 40 marks in the examination. And in corporate laws, all we have to study is just one act, that is Companies Act 2013, being administered and enforced by Ministry of Corporate Affairs, right? Okay. Now, when I say Companies Act 2013, we don't have to read the entire act. Companies Act is divided into, I hope you all are ready with your copy, with your highlighter, right? Companies Act 2013 is divided into a lot of chapters, right? There are total 29 chapters. It goes on, and there are 29 chapters in total, right? Okay. Now these chapters are further divided into different sections. So in chapter 1 we have section 1 and section 2. Likewise in chapter 2 we have section 3 and it goes on till section 22. Then the next chapter starting from section 23 and so on. Okay. This way we have the hierarchy. Okay. We have to read till section 122. This is something that I've already told you in the previous class. Okay. So don't look like what is ma'am telling, right? This is something that I'm repeating and repeating for a reason. Okay. So this is the hierarchy that this is something which is in our syllabus which we are supposed to read, and today my dear we will be starting with this chapter 1. Okay. Now there is a different classification according to Companies Act, and when we look at our syllabus given in the institute's material, we will find that okay, they have Companies Act section 1 to 122, and that all the sections are compiled in just one chapter, right? But of course, Companies Act has classified it into different chapters for a reason, and we'll be reading it like that only, of course, comparing it and aligning it with the syllabus. Okay. Now when I say chapter 1, it has just two sections, section 1 and section 2. And this chapter's name is preliminary. This chapter's name is preliminary. Okay. It has just two sections, section 1 which talks about short title, extent and commencement, and section 2 which talks about the definitions. Usually you will find in almost every central act which is being made, section 2 is the definitions. Okay. Yes, you will find this almost everywhere. So, in section 1 is this short title, act and commencement, and section 2 are the definitions. Okay, so today basically we are going to read a lot of definitions. Now, the definitions are not going to be boring at all as they used to be. They are going to be super interesting because we will be ultimately knowing what are the different types of companies. Okay, and they are very interesting. Okay, trust me on that. Fine. So, we are going to commence with section 1, not so important. Short title. I hope you're writing with me. Extent and commencement, applicability. Okay. I'm writing everything over here. Fine. So this particular act is going to be called as Companies Act 2013. We all know that. So that is basically the short title that we have, right? And the basics I have already told you. The definition here comes: applicability and extent of Companies Act 2013, right? So the Companies Act 2013 extends to whole of India. See, whenever we are talking about applicability, there is a difference between applicability and extent. When we talk about extent, it refers to the geographical boundaries. Earlier, before Jammu and Kashmir Reorganization Act, there were different laws prevailing in the state of Jammu and Kashmir. Why? We all have seen even the movie, right? So we know the basic, we have that idea. So I'll not get into that, right? Now, after this, it's one law, one nation, right? That is the concept that we are going on, right? One nation, one law, right? So it extends to whole of India. No matter in which part of India you are, if you're forming a company, if you're dealing with a company, if you're running a company, then you have to follow this particular act, right? So extent, yes, it extends to whole of India. Applicability, it applies to what? It will apply to companies only, na? It will not apply to partnership firms. It will not apply to proprietor. It will not apply to LLP. So that is what they're trying to tell us, right? So firstly, it will be applicable to the companies incorporated under the act of previous company law. Applicability, companies under Section 2, Clause 20. What do you mean by that, ma'am? The definition of company is given in Section 2, Clause 20. Ma'am, why are you saying Section 2, Clause 20? See, my dear students, there's one thing that you need to understand now, because you are doing a professional study, so you should know basically how to comprehend and read law, right? So let's see, let me take you through. Okay, so this is basically the website. Companies Act 2013 comes under which ministry? It is being enforced, it is being executed, it is being governed by which ministry? Ministry of Corporate Affairs, which is shortly called as MCA. So this is our beautiful, wonderful website or portal, which is going to be very useful for you in future when you become a professional. This is mca.gov.in, right? If we go to the acts, we can basically get the entire act right here. So Companies Act 2013, you can get the entire act and you can see that it is divided into 29 chapters. See, the last chapter is 29th chapter, miscellaneous. And then there are 7 schedules in the act. 7 schedules in the act. Okay, you will get to know about a few schedules. If we look at the first chapter, which is preliminary, it has basically only 2 sections: short title, extent, commencement and application, or applicability, whatever you call. And the second one is definition. Now, what is the difference? What is the difference when I write, maybe I have written 2, 1, or maybe I have written 3, 1. How do I read it? The very first one, Clause 1 of Section 2. Section 2, Clause 1. This is how I'm reading. The second one, Subsection 1 of Section 3. Or Section 3, Subsection 1. Why is this one a subsection? Subsection means sections are further divided into subsection, and this one is a clause. You could also say, ma'am, whenever it is written 2A, then this is a clause, and when it's written 2.1, then this is a subsection. This concept is a big no. Right here in front of you, I'm saying that 2.1, this is clause, and 3.1, it is subsection. Then why is it so? Very basic. And in very brief manner, I'm going to tell you, because otherwise I also have this particular video uploaded in YouTube. So if you want to know in detail, you can check that out. But otherwise, right now, I'll explain you very basic and simple thing. See, the heading of this section 2 is definition. There is a baseline in this act unless the context requires otherwise. So whenever we are talking about different clauses, there will always be a baseline. If I take you over here, section 3, there is no baseline. This is the heading of section 3, formation of company, and immediately the subsection 1 starts, right? You can see over here. Subsection 1 starts, a company may be formed for any lawful purpose. When we are talking about clauses, they all will be independent and not connected to each other. So when we are talking about definitions, the first clause is abridged prospectus means. The second clause is accounting standards mean. The third clause is alter includes. Appellate tribunal means. So they're all definitions and independent points. They're not connected to each other. But when we are talking about subsections, they will be connected to each other. Okay. Fine. So this is the entire procedure of incorporation. You'll read it later, right? So that is why when I am saying over here, companies under section 2 clause 20, it is clause, my dear. Okay. The definition of company is given in section 2 clause 20. What does it mean? What do you mean by that? It simply says that if you incorporate a company, let's say today, after becoming professionals, you guys decide and think that, okay, I want to not get into this professional world, but rather I want to set up a factory and do my own business. How can you do your own business? You can do your own business by opening a proprietorship firm, by getting into partnership, right? By opening a company. That is also an option available. So you 4 friends decided to form a company, right? Now, when you decided to form a company and do business under company, you have to follow Companies Act. So Companies Act basically tells you how do you incorporate a company, how do you register yourself as a company, what documents you need to provide, what procedure you need to follow and everything. So you get yourself registered under Companies Act 2013. Are you a company? The answer is yes. The answer is yes, because when we look at the definition, according to section 2 clause 20, company means a company incorporated under Companies Act 2013. But what about Reliance Industries Limited? Is it a company? Is it a company under Companies Act 2013? The answer is yes. Why? Reliance Industries Limited was incorporated long back, right? How is it a company? How is it a company under Companies Act 2013? It was not incorporated under or registered under Companies Act 2013. We very well and clearly know that Companies Act 2013 got the assent of President on 29th August 2013. So it came into picture in the year 2013. What about the companies which were incorporated or which existed before this? So they were registered in previous company law. What is previous company law? Companies Act 1956 was one of the major or most important previous company laws. Okay, even before that we also had 1913, right? So there were many company laws, Companies Act which existed, right? So if you were incorporated in all these, then also you will be called as a company. So if you are incorporated under Companies Act 2013 or under any of the previous laws relating to companies, you are still a company. Okay. So when we look at the applicability, any company which is incorporated under this act or previous company law, Companies Act will be applicable on them. Fine. Okay. Thereafter, it will also be applicable on all the insurance companies, banking companies and electricity companies, the companies which are engaged in generation of electricity or supply of electricity companies, right? It is applicable on all these 3 companies also. But. Okay. There is, see, I have already told you section 1 is not so important. So you just have to understand this to understand the entire chapter. Okay. Now let's say Companies Act, example, a fictitious example I'm taking, a fictitious example. Companies Act says minimum 3 directors. Banking Regulation Act says minimum 4 directors. Okay. So, banking company will follow Banking Regulation Act. Do you get my point? We are talking about these three types of sectoral companies which come in a particular sector. Insurance companies are of insurance sector, electricity companies, electricity sector, banking companies, banking sector. So the entire banking sector is being regulated by Banking Regulation Act, RBI, right? In insurance sector, we have Insurance Act, we have IRDA, right? Regulatory Development Authority, right? That is what we have. So they are the authority which is governing the entire insurance sector. So if you are a banking company like any other, if I say Axis Bank Limited, it is a banking company. Trust me, it is a bank, right? So it is a company prima facie which is registered under Companies Act, and then it gets the license from RBI to operate as a bank, right? So that is how it is working. So it is registered under Companies Act. It has to follow the provisions of Companies Act. At the same time, it comes under banking sector. So it is also required to comply with the regulations of RBI, with the all the provisions that are stated in Banking Regulation Act. So whenever there will be a conflict, that okay, Companies Act is saying something else and Banking Regulation Act is saying something else, then what will it follow? It has to follow its specific act. Specific act means Banking Regulation Act. This goes for all the three sectoral companies. So insurance companies, Companies Act will be applicable to you except where the provisions are inconsistent with the provisions of Insurance Act or IRDA Act. So wherever there is inconsistency, then you'll follow your specific act. The same goes for banking companies, the same goes for electricity companies. Okay. Now, apart from that, Companies Act will also apply to any other company which is governed by any special act. Like we have seen, okay, banking companies governed by Banking Regulation Act. Likewise, if there is any other company which is governed by any special act, still Companies Act will be applicable on you. And it will also be applicable to any other body corporate which CG may specify. Which CG may specify. It will also be applicable on any other body corporate. If you want to write an example, you can write over here example NHAI. So we have National Highways, NH, right? Authorities of India. That is a body corporate. It is not a company which is registered under Companies Act 2013 or previous company law. It is a body corporate, but central government has notified that Companies Act will be applicable on you too. So it is applicable on them too. Okay. What is the difference between body corporate and company? Let's check that out. Banking, insurance, electricity. So far, the provisions are consistent. Okay. Then any company governed by special act, and then any body corporate notified by CG. CG stands for central government. So this is basically the applicability. Now the next heading, or just for understanding, difference between body corporate and company, only for understanding. Okay. Company registered under Companies Act. Company is registered under Companies Act. When I say body corporate, any entity which has features like artificial person, perpetual succession, capacity to sue, be sued, etc. Since company has all these features, company is also a body corporate. Okay, so company is a body corporate, but all body corporates need not be companies, but all body corporates need not be company. But all body corporates need not be company. Example. Example, LIC. LIC is not registered under Companies Act 2013 or previous company law. So it is not a company. LIC is not a company. Mark my words, LIC is not a company. Okay. LIC is not a company, but it is a government owned entity, right? We all know that. Okay. We have LIC where it belongs to the government. That is what we know in general, right? Although there was an LIC Act, and under that act, there was power given to central government to establish such an entity, right? It is not a company which is registered under Companies Act. LIC is not a company, but since it has those features, it is a body corporate. It is a body corporate. So to become a company, you need to be established or registered or incorporated under Companies Act 2013. But to become a body corporate, all you need is these features, right? These features could be given to any entity, right? So that particular entity will be known as a body corporate. Okay? I hope this is clear. So right now, it is more than sufficient that you need to know. Fine? Okay. Now, there is one more thing which I want you to know for understanding before we actually go to the definition part. See, if you're not able to write with the same pace, it's completely fine. You can pause, you can write, you can take screenshot, whatever you want. But these are not some things which are very much relevant and will be asked for you in examination. So I have to be quick. But if I don't tell you these things, you will always have a question being popping up in your mind. What is this body corporate? What are you talking about, right? So I need to answer these basic queries and basic things. Before we go with the flow, see, in the very first chapter, you'll find a lot of basics floating in, which is not there in your study mat, or which you're seeing that, ma'am, it's not there in the book that you have provided. From where are you teaching this? So just relax. It is only for understanding, okay? It is only for understanding. See, we had done till corporate will in the previous class, right? We're starting from here. These are the important definitions, and this is the section summary that you can see over here, right? These are all the definitions that we have to read, and we'll be reading one by one. We don't have to read entire section 2. There are a lot of clauses. We have to read some selected ones. Okay, what is the definition of company? That I have already told you. The basics of Companies Act you already know. The applicability and extent we have discussed, and thereafter comes the classification of companies. So we have different types of companies about which we will be reading. Okay, but before we go on to that, there is something more that I need to tell you. What is it? Okay, so basically, company is what? Is a natural person or an artificial person? Company is an artificial person, ma'am, of course. So company is an artificial person. So who takes decisions of the company? Who has this decision making power? The decision making power lies with two people. One is the board of directors. What is board of directors? Collectively, all the directors are called as board of directors. Okay. Board of directors are elected by shareholders. So, shareholders decide who is going to manage my company. Shareholders. Okay. Responsible for management. Responsible for managing the affairs of the company. Fine. Then there are shareholders. Shareholders. Some decisions or some powers are being reserved. Companies Act tells you that, okay, there are four people who have invested in the company, who have formed a company. Now, these four people have elected some people as directors and they are managing the company. But when they want to change the name of the company, they cannot change it without our consent. So, they need to take our consent. So, some powers are reserved for shareholders. So, some powers or decisions are reserved for shareholders. SH means shareholder. Okay, fine. Who may be the shareholder? Who may be the shareholder? A shareholder could be an individual like us, right? An individual like us. It could be any company. It could be any body corporate also. Yes. LIC can hold shares in a company. LIC can invest in a company. If you talk about ONGC, I guess LIC is also a shareholder, right? Okay. And can a firm, or I should rather write partnership firm, can a partnership firm be a shareholder? The answer is no. The answer is no. Okay. So, a partnership firm is not a legal person in the eyes of law, and since it is not a legal person in the eyes of law, it cannot invest in the shares of the company. So, if you are a partnership firm and you want to invest in a particular share of the company, if you want to invest in a company, then you have to invest in the name of one partner. You cannot invest in the name of partnership firm. Okay, so partnership firm cannot be the shareholder of the company. However, an individual can be the shareholder of the company. A company can also be shareholder of another company. Okay, fine. There is one more thing that I will tell you, and thereafter we will proceed with the definitions. Okay, what is it, ma'am? There are different phases of a company. Okay. I hope you're writing this. See, these are very small things. Probably nobody is going to tell you, but this help you to understand company law and law in the manner you just cannot imagine. So you'll have a very good understanding. Trust me on this. So listen to me very carefully and make these short, small, important small notes. Okay. So here, let's say the company is incorporated. Company incorporated. See, at times you'll find that, okay, ma'am is writing in the manner we can understand. At times you'll find what a pathetic handwriting ma'am is using. So bear with me, right? When I'm writing very fast, there might be handwriting going up and down, but try to understand, because every time I'm writing something, I'll speak. Okay. Then here, the shares are issued by the company. and then here is winding up. Okay, now listen to me very carefully. Four friends decided to form a company. They have yet not formed a company. They cannot be the shareholders of the company. They cannot be the members of the company because the company has not yet been formed. They have decided to form a company. They have decided to subscribe to the document of the company. So before the company is incorporated, the people are known as subscribers. Okay. Once the company is incorporated, the same people will actually become the member of the company. Members. Once now you have become the member, you agreed that okay, I will subscribe to the document, I will incorporate this company, and I will contribute 50,000 to the company, and I will take, let's say, 5,000 shares of the company at the rate of 10 each. So I will give the company 50,000 rupees, and the company in turn will give me share receipt, the receipt, right, that they have issued 5,000 shares at the rate of 10 each to me. That is how it works, and I've already explained you this, right? More deeper understanding you'll get in the chapter of share capital. Fine. Right now, so once the shares are issued by the company, the same people are called as shareholders. They're still the members, so they may be called as the members, they may also be called as the shareholders. And once the company starts into the process of closing down, shutting down, winding up is selling all the assets, paying off the liability. So it is closing down, it is shutting down. So order of winding up is being passed. Now you're not the shareholder, now you're being called as the contributory. So the same people are subscribers, members, shareholders, and contributory during lifetime of the company. Fine. Shareholders and members are used interchangeably by us, and it can be used. But members, once they are issued shares, then only they can become shareholders. There are some types of companies wherein shares are not issued at all. The company is without share capital. So in such a situation, you cannot call them shareholders. They will always be members. Shareholders means what? Holders of shares. So once shares are issued to them, once they have contributed to the share capital, then only they can be called as the shareholders. Otherwise, they'll be the members. But before the company is incorporated, they will be the subscribers. Okay. So let's say Reliance Industries Limited was started with a few people. They're all the subscribers because they have subscribed to the document. Once the company is incorporated, they all became the members, right, of the company, right? They were issued shares, they became the shareholders, right? Now I purchased the shares from somebody else of Reliance Industries Limited, I also become the shareholder, right? So I can be called the member also, I can become called the shareholder also. Fine. Okay, so I think these basics are clear. Now we will start with the different types of companies. The different types of companies. Okay. Now, what is important and what is not important, that also you have to understand, and I will make you write that. Okay, just a second. Give me 1 sec. Because you'll find a lot of classification on the basis of incorporation, classification on the basis of liability, classification on the basis of control, right? But what is that you need to learn from exam perspective? What is that you don't need to learn from exam perspective? All of that. Okay, so write it. Very important. Three types of companies formed according to section 3 or on the basis of membership. What is it? One is private company, second is public company, and the third is OPC. You might have heard about a lot of companies, holding companies, subsidiary company, government company, not for profit companies, private company, public company, OPC, right? You have heard a lot of it, right? But to make it very simple, if you are forming a company, you can either form a private company or a public company or one person company. So if you're forming a government company, it has to be either private, it has to be either public. If you're forming, let's say, a holding company is a relative concept, right? So it is not that okay, you are forming a holding company, no, or you're forming a small company, no. You're forming either a public company or a private company or OPC. Now, these companies can be like small company, government company, or not for profit company, or like things, right? So, when we read about the incorporation of company or the process that how a company can be registered, how a company can be incorporated, you have to understand that these are only the three types of companies which can be formed under Section 3. So, a company may be formed as a private company, a company may be formed as a public company, a company may be formed as OPC. Fine? Clear? Okay. So before we go on to the this important ones, there is something else, and let's look at that also, and thereafter we will discuss those type of companies in detail. Fine. So this one on the basis of incorporation, right over here, not important. Okay, not important. What is a registered company? Which is registered under Companies Act. We have read. Okay. What is a chartered company? Chartered company is something which does not exist as of now. See, there were like East India Company. It was formed by the order of a king. That is how you can presume it to be, right? So this is something which is not relevant as on date. And then there are statutory companies. Statutory companies are like other body corporates. They are basically not company, but just for namesake they are being called as statutory companies, like we have LIC. So I already explained you the concept of body corporate. So now you very well know that okay, if I say LIC, it can be referred to as a body corporate. It may also be referred to as statutory company, but it cannot be a registered company or a company under Companies Act 2013, right? Okay. Now, on the basis of liability, we have different types of companies: company limited by shares, company limited by guarantee with share capital, without share capital, or an unlimited company with share capital or without share capital. That is how the companies can be. Okay. Now, you can either leave some space, right? Leave 1 2 pages maybe. Okay. And thereafter, what you can write is company on the basis of liability. On the basis of liability. Okay. So we have company limited by shares, limited by guarantee with share capital, without share capital, and then we have unlimited company. Again, it is with share capital or without share capital, but that is something which is not very relevant and important. Okay. Fine. Now, when I say it is a company limited by shares, I have already explained you this particular case that okay, this is a company formed as limited by shares. So the company's liability is going to be unlimited, but the liability of its members is going to be limited to the amount unpaid on shares held by them. So if I have agreed to take 100 shares at the rate of 100 each and I have only paid 50 per share, then my liability is limited to the amount 50 per share, because the paid amount is 50 and the unpaid amount is 50, and my liability will be limited to the unpaid amount only. So in this case, members liability is limited to the amount unpaid on shares held by them. Clear? Okay. The next one we have limited by guarantee. Limited by guarantee means what? See, limited by guarantee, that means if I am the member to that particular company, I have undertaken guarantee that when the company closes down and it is short of money, that means it's unable to pay to its creditors or like things, then I will contribute maximum an amount of 1 lakh. So I have taken a guarantee of 1 lakh. Now everyone who knows this will be like, okay, she has taken a guarantee of 1 lakh, so I can definitely give a loan of maybe 20,000, right? So that's how it works, right? Guarantee also helps a lot. Okay, so in this case, okay, let me first write over here without share capital. Members liability is again limited to the amount of guarantee undertaken by the member. Because all it has is only guarantee. There is no share capital. Now, let's say there is guarantee also and there is share capital also. That means I'm holding some shares also and I have undertaken guarantee also. So guarantee amount plus the amount unpaid on shares held by me, that will be my total liability, right? So again, the member's liability is limited. Members liability is again limited in this case to the aggregate of guarantee amount and unpaid amount on shares. Right? And then comes unlimited company. The member's liability is unlimited. Members liability is unlimited. Ma'am, we have this type of company also. Then what is the advantage of forming a company? That is why hardly any such type of company is being formed. So we have the companies which are formed as limited companies only. We don't have unlimited companies which are being formed. Okay, because here you don't get the benefit of limited liability, and that is one of the major advantage of forming a company, right? So here in this case, members liability is unlimited. Fine. So I hope this is clear. Okay. See, the keywords have been highlighted over here. You don't need to learn these clause numbers. Not really needed. Fine. Company limited by shares. A company limited by shares is a registered company having the liability of its members limited to the amount unpaid on shares held by them. Company limited by guarantee. Company having the liability of its members limited to such amount as the members may undertake to contribute. And unlimited companies, companies not having any limit on the liability of its members. Fine, so these are the keywords that you need to remember. Now we come to our very important, this is important. Okay, this is important. We have three types of companies which can be formed under Companies Act 2013. One is private company, second is public company, and third is OPC. Third is OPC. So first we'll start with private company, which is a huge definition. Then public company, very small, and then OPC, there is nothing, but then you need to know a lot about OPC. So we'll see that one by one. Fine. So we are starting with, what do we mean by a private company? What do we mean by a private company? Private company, private, section 2, clause 68, 8. Fine. What is a private company? Private, right? So it is a space, private. Nobody can enter into just like that. Now, just the way you have your private parties, who can enter into the private parties? The ones who have those passes, right? And maybe the one who's invited. But who can enter into a public concert or event? Anyone. It's freely available. You go, you buy it, you can enter it, right? If it's not paid, it's a public park. Anyone can go in. But if it's my private garden, only those persons who I invite can come in, right? That is how it works. So undoubtedly, private company has the members who are invited, right? And public companies may have any member. They don't go and like they say that, no, you cannot come into my company, you cannot become the shareholder. No. If I want to buy the shares of a particular company, which is a public company, I can go ahead and buy those shares. Not a problem. Right? Right? But eventually you will discover a lot of aspects when you read about public offer and private placement. Then you will discover that, okay, even if it is a public company, I may not become the member if they don't want me to, right? Unless they have come up with public offers. So that is something that you'll know a lot later, right? But right now, write a line. Whenever any company is formed, there are two basic docs needed. Memorandum of Association, that is MOA, and Articles of Association, that is AOA. Memorandum of Association contains details or fundamentals of company. Example, name, place, liability, object, etc. Articles of Association contains internal rules of company. That is, or you can write example. Example, if a shareholder doesn't pay its amount, how can shares be forfeited? You all have heard about forfeiture, right? In accounts, you have even passed entries of forfeiture. So you know what forfeiting shares means. Basically, you know what share capital is, what shares forfeiture is, and all that, right? So you have some idea, right? So these are the two documents which needs to be prepared by every company, and it needs to be filed along with other documents. Then only a company can be registered. So every company, whether it's OPC, whether it's a private company, whether it's a public company, will have these MOA and AOA, memorandum and articles. Fine. Okay. Now when I say private company, when I say private company in its articles of association will have three things. That means if you want to form a private company, then you need to incorporate these three things in your articles of association. What are these three things you need to incorporate? One is restriction, the other is limitation, and the third one is prohibition. Restriction on transferability of shares, limitation on the number of members, prohibition on inviting public to subscribe to the securities. I have said all these heavy terms, heavy three lines, right? So one by one, we'll understand all the three lines. Three things: prohibition, restriction, and limitation. Okay. Now, when I'm saying it's a private company can have how many members? 2, 4, 10, 20, right? Maximum 200. If there are more than 200 members, well, probably it's not a private company, it becomes a public company. See, I'll tell you what government vision is. Government wants to give you the ease of doing business. So if you're forming just a private company, it is just you and your friends who have invested the money and you're doing business. You are not doing business in the manner there will be a fraud within you and all that, right? They said it's okay. We're not going to regulate you much. We're not going to impose a lot of regulations and compliances and burden of filing a lot of documents on you. But if you are a public company, that means you have 500 members. Let's say, for example, a public company can be formed with just 7 members. That is not the problem. But let's say you have 500 members. There are so many people whose money is at stake, whose money is involved. Now, if you're doing fraud, then government is concerned. Government is more concerned. So they will put a lot of regulations, compliances, disclosure requirements that tell us this, where did this money go, right? And all of this, right? So basically, private company means you're operating on a smaller level. However, if you have the caliber, let's say, if I say Flipkart India Private Limited, it is a private company yet operating on such a large scale. So we cannot have this conception that private companies mean small companies and public companies means big companies. No, private companies means that you are never going to involve public money. You are never going to, if you want to do that, then you have to convert yourself into public company and then you can do that. But if you're a private company, you cannot ask money from public. That is something which government is not allowing. And you have to write this clearly in your articles of association that this particular company, because what is articles? Articles are the internal rules, right? So this particular private company will write, every private company will write that this company, I am prohibited to invite public to subscribe to my securities. That means I cannot allot shares or debentures to public. No, I cannot do that. I cannot take money from public. I cannot make these public to be the investor of my company. No, it is something which is prohibited, fine. Secondly, I have to limit the number of members to 200. So maximum numbers. Private company, minimum number of members is equal to 2. Maximum number of members is equal to 200. So limit number of members 200. Prohibit public to subscribe to securities, and restrict transferability of shares. Okay, now tell me one thing. There's a private, it's my birthday approaching, and there is a private party that I've kept in my garden over here, right? So I have invited you. You are all my dear students. I've invited you, and I have given you an invitation card that, okay, if you show this particular invitation card, you can come in, right? Now I have invited you. That means either you can come or you can decline that, no, mama, I have to study, or I am occupied, or I have to go somewhere else, so I cannot come, right? That is what can happen. That is it, right? Can you do this that, okay, if I cannot go, I will give this pass to somebody else on road, and that particular person will go to mom's private party? No, that cannot happen. So do you think that transferability of shares should be so easy? No. Shares holders means what? There are let's say 10 shareholders in a private company. One of the shareholder thinks that, okay, now I want my money back. I have invested 50,000 in this particular company. It's a private company. We all 10 friends decided to form a private company. I've invested 50,000 into this private company. And I am holding, let's say, 500 shares at the rate of 100 each, right? So I'm holding 500 shares. I want to sell this 500 shares. So I will transfer this 500 shares to somebody else. So I'll take 50,000 from that particular person and I'll give my shares to somebody else. Now that somebody else became the shareholder of this private company because I transferred my shares to that particular person. Do you think it is going to be allowed? The other members will agree, other friends will agree that we were 10 friends, we knew each other. How can you ask just somebody, anyone, to become the shareholder of our company? No, it is not possible. Yes, if you want that, consent. So there is not prohibition, there is restriction. However, when I'm talking about a public company, in public company, the shares can be freely transferable from one person to another, another to another, another to another. Okay, so that is what is the difference. So a private company means a company which by its articles restricts the right to transfer the shares, limits the number of members to 200, prohibits any invitation to public to subscribe to its securities. You got it? There are three things. Let me take you through the definition because there are still more that I need to tell you. Okay. So just a second. Fine. So private company means a company which by its articles restrict the right to transfer the shares, limits the number of its members to 200, and prohibit any invitation to public to subscribe for any securities of the company. Fine? Of the company. Now, as I told you, I have also given you the example of Flipkart India Private Limited. The same example is being given here also. Okay? Fine. Now there is something more in depth. The very first thing. Private company means a company having a minimum paid up share capital as may be prescribed. The point is, nothing is being prescribed. Now, when I say prescribed, important note. Important note. Throughout Companies Act, Companies Act 2013, wherever it's written prescribed, it means central government through its ministry MCA has the power to make rules in this regard. Actually, the power is conferred in a different section, but wherever it's written prescribed, that means rules may be made. And of course, if CG has made those rules, we have to read that rule also. So, section has to be read along with the relevant rule to get the entire provision. Fine. That means Companies Act 2013 is read with rules. I have told you this before also. Now, these rules are easier to amend because ground level central government knows. Now, central government knows that, okay, right now this is the minimum paid up capital that we should prescribe. Maybe we can increase this paid up capital. Maybe we can decrease this paid up capital, whatever it is, right? So, government can do this by changing the rules, by amending the rules. Right now, government has not prescribed any paid up share capital for a private company or for a public company. That means if you want to form a private company, you can form it with 100 rupees also. That is not a problem, right? So there is no minimum paid up capital which is required or which has been prescribed currently. Earlier it was prescribed, now it is not prescribed. Fine. So this is clear. No minimum paid up share capital is prescribed. A company may be formed with any amount of share capital. Fine. Okay. Now, when I say that the company limits the number of its members to 200, what do we mean by that? There can be maximum 200 members in a private company. But I took an example of Flipkart India Private Limited. It has so many employees. There might be a very few people who have invested in the company, that is fine. But then there are so many employees who are working in that particular company. Now, whenever a private company, or basically when we're talking a startup is being formed, there are a lot of people whose money is involved, and there are a lot of employees who every day contribute something new, who develop something new, and they need to be rewarded. And the company doesn't have enough funds to reward them in money, always. And in such a situation, equity participation is what is offered to these employees. Yes? So these employees are offered shares at a lesser value. You all know that the company's value increases over a period of time. If I have invested in a particular company, I have got one share for 10 rupees. Of course, when the company's value grows, this one share will realize me maybe 50 rupees when the company is being sold, or when I want to sell my shares, the same will be for 50 rupees, right? And it gradually increases. Now, when the employees who are working in the company, they get an offer from the company. They get an offer from the company that, okay, we want to retain you all. right? So if you stay in this particular company for 1 year, you can get our share at 5 rupees. The share is of 50 rupees, but you can get the same share at 5 rupee. So they will want to retain, they will want to work, right? So participation in equity is something which is offered to employees a lot of times. Now, there is a company which has 50 members who have been the investor and who have contributed to the share capital of the company, and there are 300 employees in the company. Is it possible? Of course, it is possible. There could be 300 employees, there could be 500 employees, there could be 1,000 employees in a private company. It's very well possible, right? So, if there are 300 employees in a particular company, and the company wants to offer shares to them, and every employee of the company takes a share, it amounts to increase in 300 more shareholders, yes or no? There were already existing 50 shareholders, so this contributes to 350 shareholders. This exceeds the limit. Do it need to convert it into a public company? The answer is no. Why, ma'am? Because it's written. Provided that, what is provided that I'll tell you later, fine? Where two or more persons hold, oh, not this one, the other one. Persons who are in employment of the company shall not be included in the number of members. For this particular section, for counting the limit of 200. Fine. So, employees and former employees. Former employees means your ex-employees who were in the employment, who got the shares, but now they have switched the company, they have left and they are working somewhere else. Fine. Employee and former employee not to be included when counting this limit of 200 members. That means, do they get the dividend? Do they get share of profit? Of course, yes. Do they get the right to vote? Of course, yes. So they get all the rights which a shareholder will get. But when you're counting this 200 limit, they will not be included. The employees will not be counted in this limit of 200. Write an example. Example. ABC Private Limited. Every private company will add the suffix private limited. A public company will add the suffix only limited. These are all limited companies that we're talking about. So private limited or only limited, right? So ABC Private Limited has 150 members. The company intends to issue shares to its 60 employees of the company. Can it do so? Can it do so? See, if there are 150 members and we issue shares to 60 more employees, the total will come out to be 210 members, right? So that will cross the limit which has been stated for a private company. A private company can issue shares to maximum 200 members, right? But employees are not counted in this limit of 200, right? So the total number of members, if we compute for this particular section, it will still be 150 only. So yes, the company can issue shares to its 60 employees of the company, right? So the answer would be yes. The answer would be yes. Okay. If you have written this important note before, it doesn't matter. Okay. Don't be like, okay, ma'am has written this here. I have to write it over here only. In a few days, you will be very comfortable with the way I write and with the way you note these things down. Fine. Okay. Clear? So we go back to the definition. Persons who are in the employment of the company and persons who have been formerly in the employment of the company, who were members of the company while in that employment and have continued to be the members after the employment ceased. So they still hold the shares, but they have left the company and joined somewhere else, maybe. Right? So still you will not be included. Whether you are a current employee or you are ex-employee, you will not be counted in this limit of 200. In this limit of 200. Fine? Clear? Okay. Now there is one more angle. The last angle that we have to read in this particular definition is that two or more persons hold one or more shares in a company jointly, they shall, for the purposes of this clause, be treated as single members. Joint members to be counted as one. Note, joint members to be counted as one. Example, ABC Private Limited has 199 members. Abhi wants to purchase the shares of this company in the joint name along with his wife. Will it amount to contravention means violation of section 2 clause 68? Right. Think and tell me the answer. Yes, I'm listening. Come on. Okay, now listen. Abhi is somebody who is newly married. Okay, so they have taken this vow, like everything they are going to do together, right? So we'll have the house in our joint name, the car in our joint name. Everything is going to be in the joint name. There will be a nameplate outside our house in the joint name, right? So everything is going to be in the joint name. So they decided to take a share of particular company. They wanted to invest in that particular company, and they thought that okay, this is also going to be in the joint name. Right? So there are already 199 members in a particular company, and then comes Mr. Abhi who wants to invest in this particular company in the joint name. So does it mean that 199 plus Mr. Abhi plus his wife, that amounts to 201 members, or does it mean 199 plus one member? 199 plus one member, because Mr. Abhi and his wife are jointly holding the shares. It does not matter you are holding 1 share, 2 share, 3 share, 4 share. You're jointly holding the share. Joint holders are one member only. One member is holding 4 shares. It doesn't matter. How many members are there? That matters. One member is holding 10 shares. One member is holding 1 share. Abhi and his wife is counted as one member. They're holding maybe 10 shares. They're holding just 1 share. They're holding 1500 shares. Doesn't matter. You will be counted as one member. You will be counted as one member. So joint holders are counted as one member. Okay. So will it amount to contravention? The answer is no. The answer is no. So when I sum up the definition of private company, if I try to sum up the definition of private company, then what is it? Private company is a company with minimum paid up capital as prescribed, right? And which by its articles restricts the number of shares, restricts the transferability of shares, limits the number of members to 200, wherein joint holders will be counted as one, and employees and ex-employees or former employees will not be included in this limit of 200. Third, it prohibits invitation to public to subscribe to the securities of the company. Yes. So joint members as one, past and present employees not included, right? That is something that you need to learn. And apart from that, there is going to be minimum 2 members, maximum 200, that you already know. No minimum paid up capital which has been prescribed, and that is it. Fine. As of now, that is it. Okay. Fine, ma'am. So I am wrapping up today's class, and we will start with one person company. Basically, first I will tell you what a public company is, and thereafter we'll do that. So we'll do that in the next class. Thank you.